Hi, Stephen. It was so nice to finally meet you here after all those contacts we have through the email and WeChat. So, how are you? And I'm also very honored to invite you as the first guest here to be in this interview series of arbitration.
I look forward to being part of the series. I'm well, thank you. I'm keeping well in Singapore in the circumstances. I think Singapore is slowly returning to a normal situation. I think in China you have really reached a certain level of normalcy. In Singapore we are slowly getting there. A small number. I think today's case there was one case within Singapore itself, and the rest were imported cases. So our numbers have gone down a lot. No, we're slowly returning to normalcy. I think we're not quite the same level as China as yet, but I think we'll get there soon enough.
So, let's get straight to the interview. My first question is based on your arbitration experience. What do you think is the difference between the traditional way of arbitration and the modern way of arbitration? And I want to clarify here, by modern way of arbitration, I mean applying technology into the whole arbitration process, such as online case filing or something like that.
Yeah, I'll be very pleased to, and thank you for asking that question. Before I answer the question, I think I should try and clarify or define what we are talking about. The world of arbitration is obviously changing rapidly, and there are, I think, different levels of online or virtual or internet arbitration. There are some institutions which are now trying to provide completely online arbitration services where everything is dealt with online. And there's even talk of using blockchain technology in arbitration and other means of even involving artificial intelligence in arbitration. I mean, these are I think somewhat in the future as yet. They're certainly not mainstream. But what is mainstream is increasing use of technology in international arbitration. And if we stay primarily with the mainstream for now, I wouldn't draw a distinction between what you might refer to as the traditional way of arbitration and what you call the modern way or the online way, because the basic structure of the process remains the same. I think the only difference is the increasing use of technology. And let me give you an example of that. When email first started being used, I remember that because I started legal practice in 1993, 94. And email had just been introduced around that time. And I remember that when I joined my law firm, it was around the time that we started using email within the law firm. And when email first started, there was a progressive acceptance of the efficacy and the validity of email. We used it as an internal mechanism to begin with, and then slowly it became accepted to be used outside the firm to communicate with other people. And then in time, it became to be accepted that this was the accepted means of communication. So it has been, and when email first started being used, arbitral institutions would say that you can email your documents to the arbitral institution if you wish, but they would insist that you send a hard copy by courier. So in that sense, it is not, you can't draw a distinction between traditional arbitration and the use of email, because the email has now become very much part of the use of mainstream arbitration. The next big change in technology that we're seeing now, and it's partly brought on by the pandemic that we've all had to go through over the course of 2020, which is the use of of web video conferencing facilities such as the one we're using now. Before, and I know this technology has been around for a while. I would have to say for myself, I hadn't heard of Zoom or Microsoft Teams or even Tencent Meeting until after the pandemic came, and suddenly we all started using these things. Having seen how it works, though, I've become a real convert, and I think we should be using a lot more of this. And because of the pandemic, we are using a lot of this now in international arbitration. As you know, in international arbitration, parties are in different jurisdictions. The tribunal is in a different country. To get people together before the arbitration community started to get comfortable with using web video conferencing, we were primarily using telephone conferencing, which isn't quite the same because I think being able to see the person that you're talking to on the video is very different from just speaking to them on the telephone and not being able to see them. And I think that this is a great tool that we can use now in international arbitration. I use it a lot now. I have completely moved from using the telephone conference as a default to using Zoom. Zoom is my primary means of web video conferencing. I use it all the time now. If I'm going to have to meet with the parties in my arbitrations, I'm going to suggest we do it on Zoom. And there's so much more that we can do on a platform like Zoom as well. We can get it recorded. It'll give you a transcript. There's so much more. And as I mentioned, there is a big difference, I think, in having a conference. I mean, having a one-to-one conversation on the telephone is not the same as speaking to you now as I do on this web interface. But having a discussion with several people on the telephone there's even more difference with that than doing it on a platform like this, where you can see everyone. I think if we do it on a platform like this, it is almost like we if I had to put a number to it, I would say I have the efficacy of I would say at least 95% of what it would have been like if we were all in the same room talking to each other. So I think it's a highly effective means of communicating. And I think we should be using this a lot more. Now, does this mean that there is a difference between traditional arbitration and arbitration using web video conferencing? I don't think so. I think it's just using a different tool to help us to do things more efficiently. I do think, though, that the ability to do this encourages us in the international arbitration community to rethink how we structure arbitration. One of the issues that we've had with international arbitration, as I said, let me use the term the tyranny of distance, in that we're not all together in the same location. And we can't gather together and meet together and discuss things together with the tribunal and the parties in a forum, whether a physical forum or a virtual forum, that easily. Well, before the virtual forum, it was primarily a physical forum. As I said, the telephone was a very, very poor alternative to meeting in person in a room. But this medium of web video conferencing, I think it's much closer to the efficacy of meeting in person in a room. And this then allows us to think that we might start, because it is easier and cheaper for us to meet in this sort of forum, we might start thinking that we can meet more frequently. And the reason why I think parties did not meet more frequently is just because if you were going to have a meeting, it would mean you travel. People have to fly in from the various parts of the world. There's the time and cost involved in that. Whereas meeting like this is even more convenient. We can all do it even from our own homes. You don't even have to go into the office. You can do it from anywhere that you have an internet connection and the right platform or computer or a tablet on which to get on. And so this suggests that we can meet more frequently. And I think this opens up the possibility that we start managing our cases differently. Now, does this mean that we are moving away from a different way of doing arbitration, what you say the traditional way, to a modern way? I don't think so. It is still the same framework and concept of international arbitration. It's just that technology is allowing us the ability to bridge or to overcome this tyranny of distance. Put it another way, do I think that we should go back to doing arbitration the way we were doing it before the pandemic made us cause us to embrace this use of technology? My answer is no. I think now that we've got the technology, now that we've accepted the technology, I think we should use that technology. So even when we can start traveling again, when the whole world returns to normal, I would still foresee that we would be using more and more of this medium because it is effective, it is efficient, it is cheaper, and you don't require people to travel as much. That's one. The other thing is we can then use this to do certain things that you might not have done because of the time and cost of it, and that involved. That I remember that arbitration was seated in Paris, and I was based in Singapore at that time. And the other parties, I think, came from London and from Japan. We all had to travel we communicated with the tribunal, I think, mostly by fax to begin with at that time. So as I said, because this is still the changeover time between acceptance of the email and fax. So email was 20 years ago. Email was still relatively new, and certainly new in the legal world. It doesn't mean that we're moving away from what we were doing previously was a traditional way. It is just a tool, but a tool which allows us to review and reevaluate how we do arbitration, which people have been talking about even before the pandemic, even before we started using this technology. It's just that we weren't aware that this technology was already here and now and ready and available for us to use.
Thank you for your sharing of your past experience of arbitration, and that is very interesting, also very insightful. So my second question is, in the process of virtual hearing, how can a third party, for example, a witness, maximize their functions? And also, what's your opinion on conducting a cross-examination on the process of virtual hearing?
Yes, so there's a lot of discussion around this now, and I think fair to say there are two camps. There's one camp which says that doing cross-examination through a medium like this is not as effective as doing cross-examination in person, physically in a room. And there's another camp that says it doesn't make that much difference. And I've done both. I've done both cross-examination in a room physically, and I was just actually earlier this week involved in a mock cross-examination where it was done on this virtual or remote medium as well. And in my opinion, I don't think it is that much less effective. I think what I said earlier about a hearing using this web video conferencing or remote means being 95% as effective as a physical hearing, I think applies pretty much to witness cross-examination as well. You also have to put this into context. And most of the time, in commercial arbitration at least, cross-examination of a witness really involves taking a witness through documents and asking a witness whether they agree with what the document says or they don't agree with what the document says. It is not usual that you have such a dramatic cross-examination where the witness is giving evidence as to a certain fact and you're trying to show that he's lying, etc. It doesn't usually come up that way. So if we're just talking about cross-examination where much of the material is on paper anyway. And all you're doing is you're taking the witness through those documents to see whether they agree with what is said in the documents or not. I really don't see that there's any great disadvantage doing this on a virtual platform like this. I mean, one of the things that people have said as well is that when you do it on a platform like this, you have a pretty clear view of the person that you are questioning. So I've got a pretty clear view of you now. It's fairly, your camera is placed fairly squarely on your face, so I can see your reaction. I can see you're smiling now. I can see your reactions quite clearly. So I don't think we lose anything in terms of seeing a person's facial expressions that much through this virtual means. Some people say that, oh, you've got to see their hands, or I can't see your hands, or we have to see their feet. Some people say that if people are nervous, you can see it through their feet, or you can see it through their hands. So, well, at least for me, in the heat of cross-examination, I don't think that I really had that much time to pay attention to what exactly they're doing with their feet. And sometimes witnesses don't really move their hands that much. So I don't think we really lose that much. There are some concerns about the integrity of the process. By that I mean that whether there is somebody else in the room with the witness, if the witness happens to be on his own, or whether the witness has some electronic means, a device in front of him where he's getting fed answers to the questions that are being put to him. He may have a phone in front of him where people are sending him text messages, or even a computer in front of him. But these can be relatively easy dealt with. One is there are many protocols now that have been published talking about how you deal with it. You could have a lawyer from the other side physically present in the room to observe what the witness is doing. You could have a camera placed there to take a 360-degree view of the room, so you can see what is in front of the witness, who else is in the room, etc. So there are many of these things that you can deal with. But does it ultimately, in most international commercial cases, much of the evidence is on paper, is documented. And much of the cases is proved or disproved on paper, or turns on questions of contractual interpretation or legal issues. Or even if you have cross-examination, it is testing the witness evidence against the documentary evidence. So if that is the case, then what is the value of witness evidence? I mean, sometimes I think the value of witness evidence is overplayed. And this is somewhat, I think, the common law influence, or the influence of the common law way of practice in international arbitration, because in courts in England and in Singapore and other parts of the common law world, witness evidence takes primacy. But that's not necessarily the case in international arbitration.
Well, Stephen, thank you so much for your sharing of your insight. And my third question is, as we all know, a major feature of internet arbitration is it's really high efficient. So while being efficient, how can we guarantee the fairness of the arbitration awards? And at the same time, how can we protect the procedural rights of each party?
So this comes back to what I said earlier before I answered your first question. So that we're not, at least when I'm talking about using technology in arbitration, I'm not talking about doing arbitration in a fundamentally different way. What we do in arbitration, even if we use technology, still observes the same concerns of due process if we were doing it without this technology. So go back to 20 years ago when we hardly used email. Maybe we used the fax. We used a lot of physical hard copy documents and carrying it around, and we were meeting physically in places. We were still observing the same concerns of due process, which is still fundamentally that a party is given notice of the claim he has to meet, and he is given the opportunity to answer that claim. So if in a particular case, I do have cases in arbitration where one party doesn't participate for some reason, or participates halfway and then stops participating, and then they stop responding, usually the respondent, and they stop responding to their emails. So what do you do in that situation? How do you make sure that the procedural rights protected? So if they stop responding to their emails and you don't know for sure whether they're receiving the emails or not, then you send a document by courier. Or if you have a fax number, you send a document by fax. So if we adopt technology, we are not going to change or ignore the fundamental procedural rights that we would require to protect, whether it was in a entirely physical hearing without the use of technology or with technology. So, I don't think technology changes that.
So besides being an arbitrator, you are also a very well-known lawyer. Another question that I'm really concerned about is that, for example, if you represent a client in an arbitration case, would you recommend to your client virtual hearing? And if your client actually choose virtual hearing, so what do you think that the party should pay attention to during the virtual hearing session? Could you please give a brief insight of that question, please?
Well, I think you can tell from the answers I've given so far that I'm definitely going to say yes, I would recommend a virtual hearing. Now, again, it depends on the case and on the length of the hearing. I think it is having meeting on this sort of virtual setting, I said, is 95% the sensation or efficacy of being in a physical hearing, but it's not quite the same. There's still that 5%. And so it's a balance between giving up that 5% and the time and cost of traveling, going back to what I said about the tyranny of travel. Right? So if it is a 1-day hearing or a 2-day hearing, maybe even a 3-day hearing, I would certainly think, yes, we should think about using this web video conferencing in place of meeting physically because of just the time and cost of it. If you have a 1-day hearing, for people to travel in and then to travel out as well, and you add in the hearing days, it's probably 3 days at the minimum, just for a 1-day hearing. So in that sense, it may not make that much sense, time and cost-wise, to do it physically, and probably meeting on this kind of format makes a lot more sense. Now, on the other hand, if we were going to have a 2-week hearing, then that changes the dynamic significantly, because traveling 1 day in and 1 day out for a 2-week hearing, is a different proposition from traveling, 1 day in and 1 day out for a 1-day hearing. And then you got to start thinking about some of the other aspects. Now, I think, this medium, as I said, is 95% effective, but there are some inefficiencies. It is said it is probably a bit more tiring that you are just staring at a computer screen for perhaps 6 to 7 hours or 8 hours a day when you have this hearing, rather than in person. The longer we are online, the more chance there is there may be some break in the internet connectivity, or some other issue that happens in technology that breaks breaks up the meeting. I mean, when I did one of my first virtual meetings, it was quite unfortunate, but I had an electricity trip in my home. That meant that my computer and my internet went out. It was quickly restored, but these are the sort of things that you wouldn't have if you were meeting physically. So again, it depends. Comes back to the point I'm making. Arbitration is meant to be flexible, and we should choose the most appropriate means for that particular dispute. So if we have a 2-week hearing, it probably still makes sense for it to be done in person. If you have a 1 or 2-day hearing, then you should really be thinking that can we do it virtually? I mean, the other problem, and this is the inverse to the tyranny of distance, which is someone called it the tyranny of time zones, meaning that well, we're kind of fortunate that Singapore and Beijing actually we share the same time zone because the distance between us is north and south rather than east and west. But you could have the situation where I'm doing a case in the United States where the other arbitrators and the party is in the US, and that's 12 hours time difference with Singapore. So it really is day and night. Now, if we are going to do it virtually because of the situation we're in now. But that means that the times that we can actually choose for a hearing are much more limited because it's difficult to find a window that will kind of work. I mean, it means that I've actually have to start hearing at night and go in relatively late at night. And in the US, they start relatively early. So these are some of the issues you've got to think about as well. I mean, you could do that for 1 or 2 days, but you wouldn't want to do that for 2 weeks. So again, these are some of the balances that you take into consideration. I think the second half to the question you had was, what should we do to ensure that the virtual hearing, the web hearing, proceeds as effectively as possible? Well, there are a lot of protocols now. Many of the arbitral institutions have come up with this. I mean, there's some very detailed about what equipment you should be using, what are the minimum system requirements of the equipment, what sort of internet connection you should have, and all that. I'm not going to go into that, but these are some of the technical minimums that you should try and meet. Although I find that in most cases now, internet connection in most part of the world is good enough. I mean,
so my last question is, what do you think is the developing trend of internet arbitration? Which means that, do you have any expectations towards virtual hearing and internet arbitration? And do you have any ideas about how can we apply technology better to the internet arbitration process?
I think you would have picked up from what I've been saying so far that I'm a fan of using technology. I think we should use technology more and more. Might be with witness evidence, right? There's some concern that you can't really see the witness that well on this kind of platform. At the moment, I'm restricted to only seeing the view that you allow me to see. Your camera is fixed, and it is only showing basically your face and a little bit just below your shoulders, and that's it. I can't see your hands and your feet, as I say. Possibly, perhaps, if this purpose-built technology was developed, it may come also perhaps with equipment that would allow the parties, maybe the tribunal says, so during this cross-examination, I want to see a full view of the witness, and you would have the functionality. Yeah, you have the full functionality of controlling the camera so you can zoom out or zoom in. It could be these additional things. I think we will learn about this as we use this platform more and more. I've learned as well. I've learned physical documents. If I have a bundle this thick, with 300 pages, if I want to flip to a particular document, I can put a simple tab in there, and if I've been through that document long enough, I think basically by sort of memory, you can flip to it pretty quickly. If I'm going to try and flip between different documents in electronically, it's still not the same because you've got to, on screen you can only have one document at a time, and then you've got to move out of that document to others. I know you can open tabs, but at the moment, I think you can open tabs. Well, at least on what I use, which is PDF Expert on my iPad, I can only open tabs of different documents. I can't open tabs of different pages in the same document. You can have bookmark, but still scrolling through a bookmark means you got to open the tab bookmark and then it moves. So it's still not quite the same. And sometimes you need to have 3 or 4 documents open before you at the same time. And it's relatively easy if you're comparing 3 or 4 documents, or when you're discussing something which is covered in 3 or 4 documents. Now it's easy enough if you've got them all open in front of you. But if you've got them on one iPad, you can't really have, you only have one screen. Then sometimes it suggests that you may have to use 2 or 3 screens, which I do use. I actually use 2 iPads. So I've got at least 2 screens, and sometimes if I need more, I've got a computer up there and 3 screens, but it's still not quite the same. So I think I would like to see the paperless, the technology of paperless documents develop further so that we can deal with it as if it is on paper. And then the other thing is how we integrate documents with the web video conferencing facilities. So I know it's possible in Zoom. I guess it's possible here. I can see it now on your Tencent meeting, the share screen. So if you wanted to show me a document, you can share your screen, but only you can control that document, and I can't control that document. If I wanted to mark up on the document, I can't do that. And so it would, what I would like to see is if technology advances to a stage where, and the other thing as well is when you share that screen, that document then takes over the entire screen, and then the pictures of the people you're talking to become these tiny, tiny little squares. So I think we should find a way, and I'm sure it will come eventually, where you can share this document without it taking over the whole screen, and perhaps some way of linking it so that, so what happens now if you share a document and I want to read that document myself? I probably wouldn't want to read the document that you are sharing, but I'll know where it is, and I'll take out my iPad and I'll open my iPad and I'll open the document on my iPad, because then as you're talking, I want to highlight, I may want to make my notes on it. And if that can be integrated better so that if you wanted to pull out a document, it would appear on my iPad automatically, and I can mark up on it, but only I can see those markups and you don't see it as well. These would be some advances which I think would deal with some of the difficulty I have right now with managing documents electronically or e-paper. That I'm sure technology will develop to bridge that gap very, very quickly. Well, we need companies like yours to start working on it. Thank you very much, Rohan. Thank you for having me.